The first case is Gillespie versus McCombs. Okay, ready to proceed?
Good morning, Your Honors. May I please the court? My name is Rafael Castro III, and I represent Ms. Gillespie, who was the pro se defendant in the lower court and is the appellant on appeal. This case comes to this court based on an order of dismissal with prejudice, dismissing the third amended complaint of Ms. Gillespie. And the key error in that order is the fact that the order required Ms. Gillespie to either obtain legal representation or suffer dismissal of the cause. We've contended in our brief that that is an unconstitutional order.
Well, let me just, before we even get to that, I mean,
Yeah.
the unconstitutional part, I mean, I don't think flies because this isn't a criminal case. And there's no, absolute right like there is in a criminal case to do it. But here's really the bottom line, the problem I see with your case. I mean, you might as well address it directly. There were three complaints that were dismissed by the trial court. And I've looked at those complaints, and they were all properly dismissed. There may have been causes of action here, but these are very difficult causes of action to bring. And, the nature of the complaints was such that I think they were properly dismissed. What the judge did was, instead of dismissing the case outright, he said, look, get a lawyer. We'll see if a lawyer can either take this case or, help you with it. Because it seems to me this is the type of case I've never seen a pro se litigant be able to proceed on. So the judge said, you can get a lawyer. The case that they cite in their brief and that you cite in your reply, you mentioned in your reply brief, try to respond to, is Barrett versus City of Margate. And in that case, there were three shots at a complaint, under the three strikes you're out rule. And the judge dismissed it, and we upheld that as not being an abuse of discretion. So here, number one, it seems that the judge could have dismissed this case outright, but decided to give your client a chance to, handle the case in a way that might produce a likelihood of success. So if that's true, if he could have dismissed the case outright, I mean, how is it an abuse of discretion under these fact patterns? Because under Margate, the three strikes you're out rule, there's no question that dismissal would have been appropriate. We would have affirmed that dismissal citing Barrett versus Margate. And where the judge tried to be a nice guy and didn't outright dismiss the case, why should we treat it more harshly than we would have had he dismissed the case outright under Barrett?
Before answering your question, Your Honor, I'd like to reserve 3 minutes for rebuttal.
Sure.
In response to that, the Margate opinion also says that in the history of jurisprudence, pro se litigants have been allowed, despite the fact that they're obligated to comply with court rules and procedures, that they are allowed leniency with respect to technical defects, such as
These aren't technical. I mean, it says, there was leniency that was allowed. I mean, he allowed, like in Barrett,
Yeah.
three pleadings. Here there were three pleadings.
Even in Margate, the court didn't say that there was a magic number. I mean, 3 isn't necessarily it. Defamation complaints, as Your Honor noted, are very technical. The key fact in this case, which she alleges in every one of her complaints, is that as the swim coach, the Brunos conspiring with Mr. McCombs said that she took showers with girl swimmers on her team. Because of that, which was published, because it was communicated to the athletic director, Mr. Costello, that caused her to lose her job. She suffered damages, and she stated that.
I understand that there may have been a cause of action here. That's
Okay.
not what I'm asking you and stuff. What I'm asking you is, I think dismissal is appropriate. And my question is, if we would have affirmed this case under Barrett, why should we treat this case differently? Because the judge, and kind of gave the appellant a break by not dismissing the case outright.
Well, Your Honor, the judge didn't really help this pro se litigant. Rather than dismissing or even allowing her to amend. What he should have done, which he could have done under Rule 1.140F, was sua sponte, strike whatever redundant, immaterial, impertinent, or scandalous allegations were in the pleadings so that the pleadings could be streamlined. Opposing counsel didn't help herself either, nor the pro se litigant, because she could have filed under that same rule a motion to strike, and she didn't. She kept filing motions to dismiss. Now, I have asked this court in my briefs to follow the holding, which was a per curiam holding, but on substantially similar facts where pending orders existed in the case. The third district in Carvey Grace, citation for which is 321 Southern 2nd 618, held that this type of condition or ultimatum in an order constitutes a violation of Section 454.18 and constitutes reversible error. Now, I think this court should use this case as a platform for extending the constitutional right of self-representation. Let me just explain why I think it's a constitutional right. The difference between criminal proceedings and civil proceedings is that in a civil proceeding, a defendant is not entitled to legal representation. If you take away the right of legal representation by, for example, putting this type of condition or ultimatum in an order, what you're actually doing is taking away the access to Florida courts for any pro se litigant. What a trial court can do in such cases, as I said, is sua sponte, strike the impertinent, scandalous, or immaterial allegations in a pleading, or it could dismiss the complaint without prejudice or with prejudice based on the failure to follow the rules of civil procedure. But it cannot put in this type of, whatever you want to call it, condition or ultimatum in an order. Because when you do that, the pro se litigant is left with no other recourse.
So you would agree that if after the second complaint, the judge said you get one more try, with or without a lawyer, and then the third one came in and it wasn't sufficient, that would have been fine to dismiss it?
Absolutely, Your Honor.
But you're saying that the judge is kind of hemmed in by giving her that one extra time, and if he had said either do it right or get a lawyer.
That's correct. In that case, she would have been put to what I've termed in my brief is a constitutional choice. You either assert your right of self-representation or you get a lawyer, which is probably the better decision, to help you in amending the pleading and maybe filing other motions.
So are you asking us to send this back and have the judge look at her last pleading and determine if it was sufficient, and if it was, go forward? If it wasn't,
Sure.
reinstate its dismissal?
Sure. I mean, that is one possibility, Your Honor. But
Isn't the standard of review whether the trial court abused its discretion?
yes, and yes and no. I mean, it's de novo on the fact that it didn't even address the legal sufficiency of the complaint. And I've cited the Hitt case in support of that argument. That's issue number 2 in my brief. But, Your Honors, this case, I believe, is the right platform for extending what this court couldn't do in Schneider v. Schneider, which the citation for which is 732 Southern 2nd, 1147. And I quote, "In that case, this court recognized that the right to represent oneself in a civil proceeding is on a scale of importance equal to the right of trial by jury." If that is the case, this is why I argued that her opposing counsel's argument is paradoxical. If we're saying on the one hand that this right is as important as trial by jury, what would be the difference in a trial court stating that you either get legal representation or you lose your trial by jury? It's the same thing that they're doing here, except the constitutional right that I believe is at stake here is the right of self-representation.
Just so I'm sorry, finish your point.
Yes. No, I finished my point, Your Honor.
Just so we're clear, though, you're not necessarily asking us to find an absolute right of self-representation in civil cases. For example, if Ms. Gillespie had been contemptuous or disruptive in some way, you would recognize that the court, within its discretion, has the ability to say, in a civil case, you cannot appear before this court without representation.
That's correct, Your Honor. To finish my point, the court couldn't go any further in Schneider v. Schneider because that was a certiorari appeal. The court said in Schneider that there was no showing of irreparable damage and that the appellant in that case had a full remedy on direct review of a final order. In this case, you have a final order. Please take this opportunity to, I know I'm out of time.
I'll give you 3 minutes
Thank you, Your Honor.
in rebuttal.
Please take this opportunity, as I said, to extend Schneider in this case. Thank you.
Good morning, Your Honors. May it please the court, my name is Virginia Sherlock, and I represent the appellees in this case. The issues in the case are not whether the appellant is entitled to represent herself or whether her third amended complaint stated a cause of action. I think Judge Gross made the point quite clearly that the judge could have dismissed this case, and it was, by the way, we're here, the dismissal of the final order of dismissal is on the third amended complaint, which is not really the fourth attempt, it's really the seventh attempt, because the record shows that this plaintiff filed a complaint. She was given permission to amend, and she filed 4 more amended complaints, one against each defendant, all of which had to be considered by the court, heard motions to dismiss. So there was 1 complaint, there were 4 amended complaints, then there was a second amended complaint, which was the final chance she was being given to file a proper pleading that Judge Metzger gave under the order prior to the order that's on appeal. And then the new judge came in and gave another final opportunity, and that was to file a third amended complaint. And the important thing to note is the judge's order did not prohibit this appellant from self-representation. It merely required that she get a licensed attorney to sign the third amended complaint. That was to get the process going. This case had been languishing for 2 years without a proper pleading being filed. The court, as Judge Gross said, clearly could have just dismissed it at the end of the second amended complaint.
Do you think if a plaintiff wants to have the more liberal pleading requirements, and really get some help from the judge, I mean, couldn't she have filed this case in small claims court and then not be subject to the strict pleading requirements, but only to the jurisdictional limit of damages?
Absolutely, Your Honor, and clearly this appellant had multiple opportunities to address the problem that she allegedly had, that she couldn't find an attorney or couldn't afford an attorney. The most obvious one is that she could have challenged the order that said you have to get an attorney. Not only did she not challenge that order.
Well, how would you do that?
Well, you could file an interlocutory appeal. I think that's
Can't she challenge it in this appeal?
Well, she's challenging it sort of through the back door because she repeatedly stated in her motions for extension of time, and there were several, that she was trying to get an attorney. Throughout this entire process, she must have, I can't count the number of times she said, I'm looking for an attorney, I'm going to get an attorney. She never once said, I need to proceed without an attorney, and you, judge, need to set aside this order that says I have to get an attorney. And the point I really want to make is she only had to get an attorney to sign the pleading. There have been cases with similar orders where the pleading is signed by an attorney and then the attorney withdraws, and the pro se litigant continues to represent herself. The Carr case that the appellant relies on was an order denying the ability of the party to represent herself at trial. That's not what we're talking about here. This case is not about not allowing her to represent herself. It's about making sure we get a proper pleading so that she then can represent herself if she wishes, so long as she follows the rules.
But if the case was about whether she can represent herself, it's the appellee's position that what this judge did, and let's say this was a policy on this judge's door, I don't allow pro se litigants to file papers in civil court. Appellee would take the position that's improper to do.
Appellees would agree it would be improper for a judge to just have a blanket policy of not accepting pro se
Or even on the
filings.
first instance.
Even on the first
In this
instance.
specific case.
But in this case, there was effort after effort, chance after chance. The orders entered by two separate judges who both had hearings, repeated hearings, and gave multiple last chance. This litigant was warned expressly in the orders, this is your last chance. It's interesting, Judge Gross, about whether a judge can kind of educate the pro se litigant. Of course, judges aren't supposed to do that. They're not supposed to help. They're not supposed to fashion the pleadings. The suggestion that the judge could go through the pleading and say, this is out and this is in and this is out, that's entirely inappropriate. Both judges in this case acted appropriately and in fact I think went beyond what they needed to do to allow this case to proceed. And of course the issue about self-representation and comparing it in the criminal context is really apples and oranges. In a criminal context, you're talking about a defendant has a right to represent himself, and he is, in fact, the defendant. In this case, we're talking about a plaintiff, someone who has begun the process, didn't have to do that, selected the forum. Certainly this plaintiff could have selected a different forum, even a county court forum, a small claims forum, which would have possibly given her a better opportunity to do it right.
What would your response be to appellant's position that it would be fine, send it back and let the judge look at her pleading, and if it meets pleading requirements, go ahead. If it doesn't, then we're done.
The appellee's position on that would be this court countenancing the willful failure to comply with a court order. This litigant willfully did not comply with a court order and did not take steps to seek relief from the order. She just said, I'm not doing it. And if this court sends it back and says, Judge, take another look, then I think this court would be ratifying a willful noncompliance with a court order, which is entirely inappropriate. There was a court order. She should have complied with it. If she truly couldn't comply with it, she could have sought relief from the order. She repeatedly states, and I believe in the brief has stated, she couldn't afford an attorney, and a lot of unverified arguments and explanations. She could have filed an affidavit. She could have sought a hearing before the court to show that she was truly unable to comply. She did none of that. She simply said, I know the order says I've got to get an attorney, but I can't. Boom, I'm going to just file it myself.
So if I understand your argument correctly, because I'm just looking at the face of Judge McCann's ultimate order, which doesn't reflect anything upon the history of the case itself, and that's what we are reviewing, that order.
Right.
We would have to write an opinion, if we were going to write an opinion affirming, under a tipsy coaching argument, basically saying that that the trial court didn't dismiss the case with prejudice, but for the wrong reason, that the court should have simply looked at it on its face, given the history of the case, and dismissed the case, and ignored its prior condition of having to an attorney review and sign the complaint.
Well, this court looks at the record, and the final order of dismissal does reflect that there were prior warnings to get an attorney. The record demonstrates quite clearly that the appellant was well aware of what was expected of her and she simply chose not to follow the court's order. And there is certainly a lot of case law that says a litigant ignores a court order at his or her peril, and this court should not countenance that by, in effect, rewarding the willful disobeyance by giving the litigant what she apparently was
But
seeking.
let's say we disagree with you on that this judge never should have, because she wasn't being contemptuous necessarily or disruptive. Looking at from her perspective, she's doing her best as a layperson to articulate her case and has really no idea how to do it other than putting in what she says. An affirmance could say this judge should have just simply looked at the case under Barrett. It was inartfully pled. The judge gave multiple chances and should have dismissed the case with prejudice. That's as simply as it would need to be put from the appellee's perspective, correct?
Correct. The court would be determining whether the trial judge abused his discretion. Clearly, he has the discretion under Barrett and many other authorities to dismiss a case when when the party is not following the rules of procedure and the orders of the court. So clearly that discretion exists, and this court would have to find an abuse of discretion in order to reverse this order, and with this record simply does not sustain a finding of abuse of discretion. Just the opposite. As Judge Gross has mentioned, this judge actually was reaching out. He was bending over backwards. He was trying to let this litigant move forward with her complaint. He was trying to keep the case going, and she chose on her own to ignore that last chance, the second final chance. She chose to ignore that and should not be rewarded for that. There's no abuse of discretion here, and the appellees would respectfully request that the court affirm the order as entered.
Okay, thank you, Ms. Sherlock. Okay, Mr. Castro.
Thank you, Your Honors. I want to address the last point that she ignored the last chance she was given. The only way that she could assert her right of self-representation was basically to do what she did, file the Third Amendment complaint by herself. Otherwise, she loses it. She would have been dismissed anyway. Whether or not the plaintiff or the defendant, is challenging this order with an ultimatum to require it, that absolutely makes no difference.
What do you say to Ms. Sherlock's, point that this really isn't an order that bars her from self-representation? It was an order that was just telling her that she needed to get an attorney to draft the complaint, and then she was free to do it on her own. And maybe, there's a million graduates of law schools out there who have put up shingles, and even a minimally competent attorney should be able to draft this type of complaint using forms that are easily accessible in 2 hours, and she would have been home free and met the pleading requirements, and she might have even gotten some pointers as to how the case might have been handled. So it's really not as broad an order, according to Ms. Sherlock, as you cast it in the first part of your argument.
Yes, Your Honor. First of all, I think that's a very cute subtlety to say that you're coming in for an appearance only for the pleading stages. Certainly there's no findings of fact with respect to that. And to address a point that I think Judge Gerber was alluding to, there's no finding of fact as to willfulness or any type of, contemptuous behavior in this case. Yes, there's no doubt my client learned as she litigated. That is what pro se, litigants do. If you look at the Margate case, and I think this is really important, Your Honors, the standard for pro se litigants is not the same standard as attorneys. There's a case that I cited in my brief, I can't remember which one, Scott v. Bush maybe. Take a look at that case where I think it was the first DCA said how difficult it is to draft defamation cases. I represent a lot of pro se litigants, not necessarily by.
Well, if you represent them, then they're not pro se, right?
Well, right, but they were pro se before I got to them. The practical difficulties of a pro se litigant in these days, going out there in the market to get a very good attorney or even a decent attorney to represent them based on pro bono or based on contingency is almost de minimis, Your Honors. I mean, that is the practical reality. You need to take that into consideration. The challenge on what she alluded to, challenging it on interlocutory review, Schneider completely foreclosed that opportunity. This is the opportunity to challenge it. She did the right thing. She challenged it on what she thought was a final review. She was harmed. She lost her job based on that injurious...
No, I agree with you. I think this is the right forum.
Okay. So the last point is that the Haynes decision, which is a Supreme Court decision, I alluded to it earlier, it sets up a different standard for pro se litigants as opposed to lawyers, is a very important case because what it says is allegations, even inartfully pled, entitle a pro se litigant to offer proof. In this case, she didn't have any opportunity to do that. She wasn't helped by the judge because the judge kept granting motions to dismiss rather than doing what he should have done, which was, pursuant to Rule 1.140F, the judge should have stricken whatever he thought was wrong with the pleading, whether the pleadings were immaterial, impertinent, scandalous, redundant. That's what that rule allows. Opposing counsel, despite her arguments, didn't help herself. She never filed that. There's a reason why that rule exists. It's to streamline the pleadings. In this case, my client never got a chance to offer any proof because she was dismissed at the pleading stage, and that is wrong. Again, because I've emphasized this so much, this is more than just what a narrow scope type of review. This appeal will affect a lot of pro se litigants. Please extend Schneider and do the right thing. Hold that. It is the right of self-representation is tantamount in terms of paramount importance to the right of a jury trial. Foreclose that, and yes, you might improve judicial economy in many cases, but you will be foreclosing the right of access to Florida courts for pro se litigants. Thank you, Your Honor.
Okay, thank you, Mr. Castro.